that you can have no contact or communication with Kayla Provost. And so she cannot give you permission to violate that court order. So whatever went on at this point, unless you have my permission to be back around her, she can't say it's fine, just come over or whatever. That's a violation of your probation. You're going to be back in here and you're so close to being done with this. You don't want to get a revocation because you could go to prison for up to 20 years. After you have worked out with Mr. Kimler, agreements in both cases,
Yes.
correct?
I'm not sure. Did Mr. Cameron do it? Discover? Yes. Okay.
See, this is, Ms. Malfino's on Ms. Clemens.
Oh, yeah.
And you got the other.
Two cases.
All right, ma'am, are you LaAsia Clemens? And Ms. Clemens, Mr. Kimler represents you in one of your cases. Ms. Holmes represents you in the other. It's my understanding you've talked with both of them this morning and have agreements with regard to pleading guilty in your cases. And are you okay going forward with just Ms. Holmes going through this paperwork and stuff with you? Okay. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Right, Ms. Clemens, in cause number 26, DCCR 1179, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then in cause number 25, DCCR 1339, you are charged with the second-degree felony offense of robbery from September 9th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes and or Mr. Kimler? Do you fully understand them? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each case is for a 5-year deferred probation in each of your cases. There would be a $500 fine in each case, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? You also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Speak up, please. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Clemens is not competent? Right, ma'am, I'm going to find that you entered your plea of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to bond?
Judge, I would defer to the court. My only concern is obviously the fact that she picked up a new offense while the underlying offense was pending before this court. And with the deferred offer, that's what it was originally. She had just rejected that. That's why we got to the trial docket.
My inclination is to leave it the way it is so that I can see if there's any other requirements or recommendations that probation might have so that we can make sure Ms. Clemens is going to be successful. All right, we'll see you back at sentencing. You can go back with the bailiff. Good morning, sir. Are you Herlin Romar Jr.? And so Mr. Romar was previously in court. He's on probation for an ag assault with deadly weapon, placed on probation back January of 2017. for a 10-year deferred probation. And there was a motion to revoke his unadjudicated probation file. We were here before. He entered a plea of true to count 5. And there was no agreement. It's my understanding now you guys have reached an agreement and he intends to change his pleas on some of those other allegations.
Yes, ma'am.
All right, so will he waive the formal reading of that motion again?
He does.
So, Mr. Wilmore, I'm going to go back through that motion, which is that motion to adjudicate or to revoke your unadjudicated probation. Again, it shows you were placed on probation January 17th of 2017. It alleges you violated your probation. Count 1 alleges that you committed the offense of assault, a Class C misdemeanor, January 24th of 2026. And is that true or not true?
It's true.
And then count 2 alleges that you failed to avoid injurious or vicious habits by shoving and pinning a Kayla Provost against a vehicle and then ripping the weave off of her head on January 24th of 2026. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to your probation officer that arrest. Is that true or not true?
True.
And then count 4 alleges that you were at a location other than your residence at approximately 12:55 a.m. January 24th of 2026. And is that true or not true?
True.
All right. Did you enter your pleas of true now to counts 1 through 5 freely and voluntarily? And have you pled true to all of those counts because they are actually true? So I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you go over these before you signed them with Mr. Lewis? And do you understand if I follow these the agreement that you've made that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've made is for me to continue you on probation, to order a 180-day jail sanction. But for these violations, it's my understanding you've already taken care of the underlying offense as well in JP court. Is that correct?
Yes, ma'am.
And that you would be given credit for 90 days of that 180 days. Is that also your understanding?
Yes, ma'am.
I'm assuming that for the remainder of the probation, there would also be a remain away from a Kayla Provost. And so if that wasn't a condition of anything, it is now. It'll be a condition of your probation that you can have no contact or communication with Kayla Provost. And so she cannot give you permission to violate that court order. So whatever went on at this point, unless you have my permission to be back around her, she can't say it's fine, just come over or whatever. That's a violation of your probation. You're going to be back in here and you're so close to being done with this. You don't want to get a revocation because you could go to prison for up to 20 years.
Yes, ma'am.
This is the turning point. The judge isn't just handing down punishment, she's giving one final warning. Legally, probation is a privilege, not a right. Ignore this no-contact order even once, and that second chance could disappear, opening the door to a prison sentence of up to 20 years.
All this time. So do what you're supposed to do, and you should be fine. So state sentence number 1,
No, yes, ma'am.
it's admitted any evidence Mr. Romar is not competent.
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke the probation, but I'm not going to do that. I'm going to follow the agreement that you made and continue your probation. Order that you complete 180 days jail sanction, but that you get 90 days credit for that as well. Okay. I'm going to hand you the trial court certification. Shows this was an agreement that I followed, and so you've given up any right to appeal. All right. Good luck to you, sir. Thank y'all.
Thanks, Judge.
1. Today's hearing featured 2 very different defendants, but the same lesson. One accepted guilty pleas and earned a chance at deferred probation. The other admitted multiple probation violations and still avoided prison for now. In both cases, the courtroom made one thing clear. A second chance comes with strict conditions, and the next decision could determine their future.